Hello and welcome to my channel Happy Hours. In the last video, I discussed about the President, his discretionary powers and about his veto power. Vice President, his role and about the councils of ministers. Today I am going to proceed further with a brief discussion about the size of the Council of Ministers, Prime Minister, Attorney General for India and about the Parliament and its structure. So let us proceed with the first topic, which is about the size of the Council of Ministers. The size of Council of Ministers was fixed by the 91st Amendment Act 2003. In the union level, it should be including the President and not exceed 15% of the total members of Lok Sabha, whereas in the state level, it should include the Chief Minister and 15% of the total membership of the state legislative assembly, but the minimum should be 12. In the states of Chhattisgarh, Jharkhand, Madhya Pradesh and Odisha, there has to be a Minister of Tribal Affairs. It is described in the article number 164. Now we are proceeding with the responsibilities of the ministers, means to whom the ministers are responsible. At individual level, there are two levels. One is the individual level and the second one is a collective responsibility. So let us discuss about the individual responsibility. In the union level, it is mentioned in the article number 72 clause 2, a minister is individually responsible to the president. That is, the minister holds the office during the pleasure of the president. The president appoints the minister and only the president can remove him. Now in the state level, under the article number 164 clause 1, it is mentioned that at the state level, a minister is individually responsible to the governor. Now we should know about what is the collective responsibility. Means whole council of minister is responsible to whom? There are two levels again, union level and the other is the state level. In the union level, it is described in the under article number 75 clause 3. The council of ministers is collectively responsible to the Lok Sabha, whereas in the state level, it is mentioned in the article number 164 clause 2. The council of ministers of state is collectively responsible to the state legislative assembly. Now these both are based on the principle of swim and sink together. That is, no confidence motion can be introduced and passed against the Council of Ministers and not against an individual minister. Now we should know about the Prime Minister. We all know he is the head of our state. Now the duties of the Prime Minister respect to the furnishing information to the president, which is mentioned in article number 78. The prime minister is duty bound to first to communicate to the president all the decisions of the council of ministers relating to the affairs of the administrations of the union, including proposals for legislations or intended legislations. Second one is to furnish such information relating to affairs of the administration of the union and proposals for the legislation as the president may call for meaning that what are the bills which are going to be introduced in the session, and about this all the information should be given by the prime minister to the president. And the last one is the if the president so requires to submit more for the consideration of the Council of Ministers, any decision taken by an individual minister but not been considered by the Council of Ministers. If suppose a minister has taken a decision on his own and president want that this decision should be reconsidered by the Council of Ministers, he may call the president and ask for do so. Next, we are having the role of the Prime Minister. We compare role of our Prime Minister as with the United Kingdom Prime Minister, as both the countries are having parliamentary system. The UK Prime Minister is the primus inter pares, which means among the equals. First among the equals. There is a question which can come in the any exams to analyze that is the Indian Prime Minister, primus inter pares, or more than that? We are going to be asked that analyze this statement. And the answer for this is the British scholar Harold J. Lasky, commenting on the role of Prime Minister in the parliamentary form of government, had given the view that the Prime Minister was central to the formation of Council of Ministers, central to his life, and central to its death. So, as India is having a parliamentary form of government, the views of Lasky holds good for India as well. It is on the advice of the Prime Minister that the President appoints the other ministers. He allocates portfolios among the ministers, and if the Prime Minister resigns or dies, the whole Council of Ministers ceases to exist. The Prime Minister is the sole link between the President and the Council of Ministers. Under Article number 78, the Prime Minister is duty bound to communicate to the President all decisions of the Council of Ministers, including intended legislations. The Prime Minister chairs the cabinet meetings and sets the agenda for such a meeting. He can interfere in the affairs of any ministries and can ask for information from any minister as a matter of right. It has been observed that the Prime Minister generally heads the following ministries. First, the Ministry of Personnel, Training, Public Governance, Pension, and the Administrative Reforms. Then, the Department of Atomic Energy and the Department of the Space. Apart from these ministries, the Prime Minister is in charge of those ministries which have not been allocated to any minister. The Prime Minister can interfere in any ongoing debate in the Parliament. The Prime Minister is the main spokesperson of the Government of India, and at the time of national crisis, the whole country looks toward the Prime Minister for a statement. Thus, on the basis of the above analysis, it may be concluded that an Indian Prime Minister is not the primus inter pares, but more than that. But the position of the Prime Minister depends on his personality, the political condition of the country, and his position in the political party. A Prime Minister leading a coalition government may not be very powerful, as he cannot take independent decisions in the appointment of the ministers and in the allocation of the portfolios. The policies are also made in consultation with the coalition partner, which is not in the case of the PM from a political party who is having majority on its own. So depends on the different condition, the roles of the Prime Minister. Next, we should proceed with the next topic, which is the Attorney General for India. It is a constitutional office provided under the Article number 76 of the Constitution. He is the first law officer of the Government of India, and he is appointed by the President. He should be qualified to be appointed as a judge of the Supreme Court. The term is not fixed, and he holds the office during the pleasure of the President. Remuneration is not fixed, and he gets such remuneration as the President may determine. The Attorney General can do private legal practice, but he cannot be a lawyer against the Government of India or shall not advise against the Government of India. Next, what are the duties of the Attorney General? He gives advice to the Government of India on legal matters. He has to perform such other duties of the legal characters as may be referred to him or assigned to him by the President. The Attorney General shall appear in the cases in the Supreme Court in which the Government of India is a party. The Government of India may also require the Attorney General of India to appear in the High Court in any case when the Government of India is the party. Next, what are the special powers of the Attorney General? There are some special powers granted to him, and those are, like, first is he has the right of audience in all the courts within the territory of India. Under Article number 88, the Attorney General has the right to speak and to take part in the proceedings of Houses of the Parliament. and any of its joint sessions also, and in any committee of the parliament of which he has been named as a member without the right to vote. The same powers are being given to the ministers also, but they are having the power to vote also, or we can say they are having the right to vote. Next, the attorney general is assisted by the solicitor general and the additional solicitor general, means they are there to help him. It cannot be the condition that the attorney general can present in all the courts, so he is being allotted with some helpers like like additional solicitor general and the solicitor general. These are also known as the law officers. They are statutory officers. They have been created by the Act of Parliament and they are appointed by the Ministry of the Law and Justice. Now, the next, if the Attorney General is there for the whole India, there should be someone who is for the state, and these are known as the Advocate General for the state. It is a constitutional office provided under the article number 165 of the Constitution, and they are appointed by the governor. The eligibility of these people are that they should be get appointed, or they should have the eligibility to get appointed as a judge of the High Court. They hold the office during the pleasure of the governor of the state. That here also the same thing happens. Remuneration are not fixed and they are decided by the governor of the state. Next, what are the duty of the Advocate General? The duty of the Advocate General is to give legal advice to the state government. Under Article number 177, the Advocate General has a right to speak in and to take part in the proceedings of the state legislature or any of its joint session, and in any committee of the state legislature of which he has been named as a member without the right to vote. Now we are proceeding to the next part, and which is the very important part of a country, that is the parliament. Now we should know why there is a need to have a parliament. The answer is it provides the member to the Union Council of the Minister. Now there are two important functions. First is the deliberative function, and the second one is the function for representation. Now we are going to discuss about the deliberative function. First is to make laws for the smooth administration of the country, to discuss the issues of the national importance. It provides a platform to the opposition to scrutinize the policies of the government. It puts a check on the government, including financial check. Now, whom it is going to represent? The first one, it is going to represent the people in the Lok Sabha. It is going to represent the state in the Rajya Sabha, and it is going to represent a certain section of like scheduled caste, scheduled tribe, and the women. Now there is an important question which comes to our mind, that is the parliament a sovereign body? So let us discuss it also. Although in the composition of the parliament, India has followed the British model or pattern, we can say, but the Indian parliament is not sovereign like the British parliament. The constitution has created all the three organs of the government, including the parliament. The parliament must exercise only the powers conferred on it by the constitution by following the procedure laid down in the constitution. If a law passed by the parliament is not in accordance with the provision of the constitution or the spirit of the constitution, that is the basic structure of the constitution, the Supreme Court is having a power to declare it as invalid. Now the next part is what is the structure of the parliament. A parliament consists of a president, council of states, which is known as Rajya Sabha, and the House of State People, which is known as Lok Sabha. The president is a part of the parliament because of the legislative functions performed by him. Now we are going to discuss about the Council of the States, which is also known as Rajya Sabha. It is the federal chamber of house, as it represents the states in the parliament. The maximum strength of the Rajya Sabha is 250 and present strength is 245. There are 12 members which are nominated from amongst the persons having the special knowledge or experience in the field of art, science, literature, or social services. The representatives of the states are elected by the elected MLAs of the concerned state by proportional representation with single transferable vote. The term of the members, it is for 6 years, and 1/3 of the members retire every 2 years, and it is also known as the permanent house. We have taken these from the US Senate. Now, the presiding officers of the house. The vice president of the India is the ex officio, which means by the virtue of the post is the chairman of the house. The deputy chairman is elected from amongst the members of the house by a simple majority and can be removed by the resolution of the house passed by a majority of all the then members of the house, which is also known as the effective majority. Now, as a conclusion, I want to tell you that the chairman not to be preside over the sittings of the councils of the state, while any resolution for the removal of the vice president from his office is under consideration by the chairman shall not have the right to speak and to take part in the proceedings of the council of the state, but shall not be entitled to vote at all on such resolution. By this I am concluding. Thank you.